Good afternoon, ladies and gentlemen. Small bit of formality, since we have a quorum, I'm calling to order the meeting of the Rutland Ad Hoc By-law Committee for January 21st, 2024. For those of you who don't know me, my name is Peter Crane. I happen to be chair of the By-law Committee. Also in the By-law Committee, present Anita Carlson, our town clerk, Norm Anderson, who's also on the planning board, and Lynn Turcott, who's also on historical commission or society or both? Both. I should have known. As I've said before, I have a presentation to go through, and then my notion is to walk through the document that describes the changes of the bylaw. I don't intend to go through every single bylaw. I don't think that's a good use of our collective time. But if we need to refer to bylaw, I have the text of those available as well. Before we get into the presentation, this has been an incredibly long journey. It's actually been nearly 10 years for Anita and me, and less time, but no less stressful time for the rest of the committee. So I would like to, first of all, thank the committee for all the work that's been done. It's been very hard work, and we're happily very nearly at the end of our journey. I'd like to thank all the boards and department heads and people involved in the review of the bylaws. If a bylaw is about a committee, that committee reviewed the bylaw, or a department did. The police did a lot of review. And the select board, I have to especially call out and thank, alas, they're not all here, but because they put in a tremendous amount of work also more recently to get through and review all of the bylaws. There have been more hours than I care to think about spent on these. Having said that, oh yes, finally, let's not forget to thank everyone who showed up today. Thank you. I appreciate you being here and you're showing interest in us. My intent is to have this meeting last about 3 hours. We'll get through as much of the changes document as we get through. Next Sunday at this time, we'll start where we leave off and move forward. My intent is to not stop any discussion. That's why I set up 3 hours. We want to discuss anything for 3 hours, let's do that. If it gets too repetitive or redundant, I may stop then, but as long as we're coming up with new things to say, we're all interested in hearing. Having said all that, let's go here and go. Nope. I ask this question. Here.
Peter, I got a quick question there.
Yes, sir.
So based on what you just said, the intent is to, all these 4 weeks you have established for meetings is to start now and go through. It's gonna continue every week, or is it gonna be the same material presented to other people that maybe couldn't make today, they're coming on week 3 maybe or something?
Okay, if we go through the entire document today, then next week I'm gonna do the entire document again, and every week after that.
Okay.
If we get through enough basically we go through it in as many meetings as it takes, and then we start again at the next meeting.
Okay, I got you, all right. I guess the only other thing is it gonna be coffee each time?
That is one of the things, yes. My wife told me I should have advertised that we'd have coffee and snacks.
Yeah.
And I meant to have tea, but I can't get to the hot water maker today, so. Here we go. A discussion about bylaws, and this is going to be a lot of background for everything that we do today. Some of you have already seen an earlier version of this. This is much more updated because it's finished at 10:15 this morning. Talk about the history of bylaws in town. We'll talk about the committee, its charge, what we've tried to do, and where we are. Well, we know where we are. And what needs to be done afterwards, an understanding of where we are in the process. And then we'll go through what I call the consequential changes review. History. From 1732 until 1895, the town had no bylaws at all. Doesn't mean there was no law, just nothing specific to the town. Mass general law has been around much longer than that. In 1895, the town passed the first bylaw dealing with the hot button issue of the day, truant scholars. And it stayed that way until 1904, when two more bylaws were passed. One about government structure and processes, and another about public decency, posting bills, constables, and its hot button issue of the day, frightening horses. In 1940, somebody said, and I don't know who initiated it, I don't have that much history, but in 1940, it was decided that the town would look into having a comprehensive set of bylaws. And so in 1941, town meeting passed these 6 bylaws. And that's the start. The other 3 bylaws were repealed, it's just these 6. Ever since then, yes, 1941 to 2024, bylaws have been added or amended or repealed as things happen in town. There was a situation or a condition or an event that made somebody say, we need to write a law about that, and somebody did. Sometimes Mass General Law changed, which enabled the town to write certain bylaws. Today, there are 35 of them, and there is, for those who have looked, no structure or organization. As a result, in 2017, the Select Board formed the Ad Hoc By-law Committee. It was intended to be short-lived and responsible only for the codification, the look and feel of the bylaws, to make things look like we have a single body of bylaws. We were also specifically charged with creating a bylaw for a permanent bylaw committee, which we did and was adopted in 2019. And it was intended that we be done by 2019 annual town meeting. Because we're here discussing this today, as you can guess, that didn't go according to somebody's plan. Why not? Our current bylaws have lots of problems. And we'll talk about this in a second, but the Attorney General has to review each and every change, small asterisk, to every bylaw that is proposed and adopted at town meeting. Well, if we have conflicts with state law, there is no chance the Attorney General will approve that amendment and will in fact strike the law completely. In addition, it's not just Mass General Law that's changed, court cases happen, and the ruling in a court case implicitly changes the effect of either a Mass General Law or a local bylaw. And our bylaws have not been examined in a way to look for those changes. So any conflicts there, they're still there, and again, would not pass Attorney General review. There are things in our bylaw that are different from how we behave. We've been mostly ignoring that for a long time. And so part of what we want to do is to ensure that the way that the town behaves is legal by our definition of legal in our bylaws. In addition, the codification piece, there's never been an organization, structure, style. They're all over the map. I find it interesting that if you get a copy from the town clerk's office, it looks different from if you look on the website. As a result of all of this, in 2019, our charge was updated to, well, start with the same one as before, codify, consistent format, presentation. Then also to find the problems that we know we should find with conflicts with Mass General Law and case law, and with our current practices, update the bylaws so that they can reflect everything that we know today. Prepare the body of bylaws, and hold information sessions like this to discuss them. This has been the review process. We, the committee, go through the bylaw, sometimes with explicit input from some SME, subject matter expert, somebody who knows something about the specific law, sometimes on our own. And we pass those changes off to a subject matter expert to review. That goes on a cycle until the committee and the expert are satisfied, and then it goes to the select board for review. Once that's done, it goes to legal review. Now you'll notice that what comes next, the public information session like we're in now, does not have an arrow back because it's too late. We can't get our review, subject matter expert review, select board review, legal review before town meeting. The bylaws are locked. That is not to say, you folks, nothing you say is of value. I'm going to say that it won't change the bylaws that we are going to propose. There will be, I am assured by the select board, a permanent bylaw committee formed soon. They had discussed it 2 weeks ago. They'll discuss it tomorrow night and begin advertising for it so that they can appoint a permanent bylaw committee and we can transition work for the future to the permanent bylaw committee. But for this round of bylaws, they're effectively locked. And of course, we go to town meeting for adoption. I wanted to give a little more detail on what happens in a bylaw. We've already talked about a bit of this. Somebody, in this case, our committee, proposes something, and there's a review process. The select board places, now this is what I call the positive flow. Everything here is, it passes. If it stops for any reason, the whole process stops. So if the select board does not place articles on the warrant, well, there's nothing else to do. So the select board creates the warrant, town meeting votes to adopt, and assuming that bylaws get adopted, that the town clerk has up to 30 days to create a package for the Attorney General to review the bylaw changes. And then the Attorney General's office has 3 months to do that review and get word back to the town as to the AG's view on it. The AG can accept with comments, which is the most often, reject portions, or reject the entire thing. Those are all options of the Attorney General's office. And until they feed us back the information in those 3 months, that's the way it goes. So assuming the AG's office approves the bylaws, town clerk posts it, usually in a day or two. When it's posted, publicly posted, the bylaw is effective. Therefore, everything that we talk about at town meeting next month will not be effective at town meeting in May. There isn't time. Unless the AG's office suddenly becomes hyper fast, that is not very likely. In fact, if anything, I expect them to take longer because of the number of bylaw, just the size of the body of work that we are passing to them is substantial. Questions on any of that so far?
So these changes here
Yes,
have not been approved by the Attorney General's office yet?
correct. They can't be until they're approved by the town at town meeting.
Oh, okay.
And some of the changes, after going through the subject matter experts, were changed when they came to the select board.
The select board has changed some, yes, that is true. And legal review has changed some as well. In fact, yesterday I put up the most recent versions. Yes, ma'am.
I know that you said that at this point in time, there can be no changes to the bylaws that are being
To
proposed.
the text of the bylaws that are being proposed, yes. Until we get to town meeting. So once we get to town meeting, anyone is allowed to offer an amendment to change the text of a bylaw.
Okay. So at that February 15th meeting, we're not voting to say this is what's gonna happen, right?
No, we are.
Yes, you're voting on, that is exactly what it is. And it's at that meeting that someone can say, I don't like this detail, I would like it changed. Or, I don't want you to change this bylaw, remove it completely.
And that can happen, or
Yes.
it
Absolutely. The whole purpose of town meeting is to discuss as a town, for all the people who are present, to agree, I mean, in terms of bylaws, to adopt an amendment or not. Or to change the wording. Something, change the wording in a different way than our committee proposed. Okay?
But these bylaws so far have gone to our town council for
Yes.
review.
Yes.
It's all done. So after the town meeting, then it goes to the Attorney General give it the final blessing if everything's okay.
Correct.
Now, if there was a change proposed at that town meeting, would it go back to the committee at that time,
There is a process that town clerk and I haven't worked out. Fundamentally, a person, probably me, will end up typing whatever, if somebody amends a bylaw at town meeting, I'll update the text before we send it to the Attorney General's office. I say I, because I'm the person I'm the typist, I keep everything, I have copies of everything.
Now, if hypothetically, you were to just rule one out completely, who would make the final decision whether it goes to the AG's office or not?
Town meeting decides. Whatever town meeting decides, so let's say I don't like this new animal control bylaw, and I want to stick with the one that we have. And the town votes to amend, complicated. So there's a motion that's going to say, propose an amendment of these bylaws. Someone can make a motion to not amend animal control. And if the town votes that way, then changes to animal control are gone, and we go back to the current version.
Peter, can I just say, and the packet that our office has to send to the Attorney General's office has to include our minutes from the town meeting. It has to show every change, how it was adopted, the number of votes, so that the Attorney General can track everything from what the handout at town meeting is to the final town meeting vote, so it's a process.
Now, there was a discussion well before the meeting began about the size of the document. The document's more than 150 pages. I am not going to propose that we give that as handouts at town meeting. If people haven't read the bylaws before town meeting, they're not gonna get through them. I intend that the town administrator provide copies of this changes document as a guideline to what's being changed, even though it's not the pure text. Other questions? Where are we? So let's start with what we've done. First, we created an organization of 8 chapters. They're all listed here. I'm not going to read them out to you. Some bylaws actually fit in multiple chapters. The one I use as my most frequent example is Finance Committee. Finance Committee is a multi-member body of the town. But Finance Committee is intimately involved with financial affairs. Where to put that bylaw? We chose to put it in financial affairs because we care more what the body does than what it is. I may as well take a moment now and say tomorrow night's select board meeting will settle this once and for all, but I have proposed, the committee proposed 3 warrant articles. The first 2 chapters are Article 1. The next 3 chapters, which is the rest of government, is Article 2. And those 3 chapters are Article 3. We expect that if there is controversy, it'll be in Article 1. We do not expect a lot of controversy in Articles 2 and 3. But as always, town meeting finds a way to surprise us. Not only did we create an organization, we created a consistent look, feel, and structure to every single bylaw. Every bylaw. Section 1 is a purpose. What does this bylaw do? Why is it here? Section 2 is authority. There can be up to two or three things that are listed in authority. Authority part 1. What part of the Massachusetts general law or the Massachusetts Constitution allow us to write this bylaw? If there is no enabling statute, we're not allowed to write the bylaw. It is not unusual to see Article 89 of the Massachusetts Constitution, which is the Home Rule Amendment, which says you can write a lot of bylaws that are not offensive to the general laws, I believe are the words that they use. Another thing that is sometimes an authority is what body is responsible for enforcing that bylaw. It depends. Section 3 I have here listed as definitions. Any bylaw that has definitions, they are section 3. If a bylaw doesn't have it doesn't have definitions, then it continues right into the natural flow of the bylaw. Not only have we created a structure, we are documenting in the body of the bylaws themselves the history of every bylaw. This happens to be the history of the general provisions article. There is one today that was passed in 1941, amended in 81, amended again in 2017. And I put it in here because it's intended to be amended at the June 15th meeting. This is before I put in Article 1 because I didn't know when I took this snapshot what the article number was going to be. Actually, I want to take another step backwards. The warrant for town meeting is likely to have 6 articles total because there are 3 zoning amendments. One of them goes along with the general bylaws. The other 2 are, we need to get these done sooner rather than later. Most of the bylaws are through legal review. As you can see, scenic roads, stretch entry code, and public consumption and water use restrictions we're still waiting for feedback. Water use restrictions, point blank, is my fault, because when I gave all the bylaws, I somehow missed water use restrictions when I was passing it off to town council. It was sent this week. The other ones, they told us they're still looking at a couple things, so as soon as we get feedback, we will integrate those. So for those 4 bylaws, we do not expect substantive changes, consequential changes from legal review, but it's possible. We may have to update some of our tables as we get through the changes. In addition, there are now 4. We originally started with 2 bylaws that we weren't going to do. But legal feedback on door-to-door solicitation bylaw basically said, no, start again, here's a model for you to start with. We can't get that work done in time for town meeting. We can't. As a result, we are pulling both door-to-door solicitation and the proposed repeal of fingerprint-based criminal record background checks. What a horribly long name for a bylaw. The earth removal bylaw is being worked on. There's actually a new bylaw in the works from the Earthworks Board. And so us doing the work to get an amendment through is not value. And signs is too big, hairy, complicated, and in my own adjectives is awful. For a general bylaw, it's just, so those are all work that the permanent committee can get to ASAP. Now, there is a little bit of a wrinkle that we discovered. Some of you may remember we had intended to do bylaw changes not last annual, but the November before that. And it is the last minute of legal review when they said, you need special legislation. What special legislation? It's a special law passed by the legislature, by the House and the Senate of the Commonwealth. Remember what I said, that we have bylaws that conflict with Mass General Law? Some of our actions also taken at town meeting have conflicted with Mass General Law. So back in 2007 and 1974, some of the actions taken by town meeting should not have done, we should have done special legislation then. So the special legislation, S-2371, deals with the change in size of select board from 3 to 5 members, and that's the 2007 vote. And in 1974, when the town voted to create a board of public works, there was another ballot question that asked that the select board, whether or not the select board should act as the board of public works. Those are both actions that required special legislation.
And our town council didn't know that.
In 1974 and 2007, that's correct. We have different town council now.
Yeah.
S 2371 has been passed by both houses. It's waiting to be engrossed. What does that mean? The legislature takes all the special acts, or a bunch of special acts at a time, and puts them together into a single bill that goes into for signature to the governor. As soon as the governor signs it, it's law. We are waiting for that engrossment and that signature. We expect it all to be incorporated in the acts of 2024. It's actually possible they might be engrossed and incorporated into the acts of 2023. I actually saw the most recent adoptions to the acts of 2023 were signed by the governor in early 2024. I don't know about that. We'll have language in the motions to deal with the fact that 2371 may not be passed and it can't be effective until after the governor signs it. Now, there are two types of changes as far as the AG's office is concerned. There are editorial changes. Hey, somebody misspelled a word. Happens all the time. In addition, there are numbering, and the town clerk's office is authorized by our current bylaws to change the numbering of anything. That's considered an editorial change. So if they want to re-sequence, you want a different set of chapters or a different sequence of articles. Town clerk's allowed to do that and they don't need town meeting vote. And along with any editorial text that is not technically part of the bylaw, so footnotes and the history are part of that, substantially it. Anything other than that, you want to change a word because you think that word is wrong, you want to add a comma or remove a comma. Any punctuation is a substantive change to the bylaw, and every substantive change must be approved at town meeting. Wow. Wow is right. So we have substantive changes. Virtually every single change made by the committee is a substantive change and needs approval at town meeting. But if I were to try to list every single substantive change, every change of word choice, every change of paragraph, because we don't like when you have large paragraphs of text. I like to have one thought in one section at a time or subsection. But doing that is a substantive change. And if I try to list all of those, the changes document is out of hand, is longer than the 150 changes because we need to describe everything. So we came up with the term consequential. That is to say, a change that is consequential is something that changes the intent or effect of a bylaw. And there are lots of those because, well, Mass General Law has changed and court cases have changed and the way that the town behaves has changed. I have an example here. Town meeting quorum changed from 10 to 30. It's an easy change, but it's substantive and it's consequential. Because that forces there to be voters, not just select board, FinCom, town clerk, moderator at the meeting to have it be legal. We have that separate document, which you have now, which describes each of these, and you'll find more text at the beginning because I only know how to write and speak for too long. Bylaws are not perfect. I'm not trying to say that they are. The first thing we need to understand is we never tried to set out how should the town behave. Should we have a town manager instead of a town administrator? Should the select board be 5 or 7 members? Should this committee do this action instead of having that responsibility? That we did not feel was our place. Our place was to describe what is. How do we behave? What is our structure? And not try to answer how should we. Those questions, how should we questions, are much better for a charter or the permanent bylaw committee, depending upon what the select board starts out, actually forms for committees. I would actually maintain the charter committee makes a lot of sense for this town, having a formal charter, but it will take work and time. part of our work, our intent was to feed into a charter committee, which is why we set up the structure that we did and set a lot of the changes. Yes? You look like you're getting ready to ask a question. No? Okay. And as I've already said, the Ad Hoc By-law Committee is happy to transition to the Permanent By-law Committee when it gets formed and up through town meeting and beyond, through the Attorney General's review. This committee is, our intent is to stick around, I'll say it now, until after we get all the comments back from the Attorney General's office. Integrate whatever else needs to be integrated, and then, poof, we'll be gone. Which sets, by the way, a deadline for the Ad Hoc By-law Committee to be formed and ready to receive work. Please, 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 please don't pick and choose individual bylaws. Let me go to the bottom small print. Bylaws interact with each other. If we take this one but not that one, what is the effect? And I don't know that anyone, including council, has analyzed what happens if the select board changes pass, but the town administrator bylaw does not. For example, it's tricky and will likely create conflicts that I don't know how we resolve, since we wouldn't have a bylaw for anything that isn't passed.
Yeah, but you said a little while ago, if they don't like the animal bylaw, they can choose to not pass it.
That is true. And that is all technically correct. I would just, now that I'm at this part of the text, I want to warn against that. I'm not saying don't do it. It is a power of the town to make that decision. I'm just warning you to say that if you go down that path, there are likely unintended repercussions. So it is available. It's an option that's available. I created a mediocre metaphor where the body of the bylaws, the 8 chapters, like a building. Chapter 1 are the footings, and chapter 2 is the foundation. Everything builds up from there. Chapters 3 through 5, the rest of government, are what I call the load-bearing walls that allow chapters 6 through 8, typo, are the interior walls and the finishes. Okay, and the roof. Roof is important. I'm not saying that those aren't important. I'm saying that the closer you are to the beginning of the bylaws, the more destructive it is to the structure as a whole if you don't pass it. I think. Oh, right. So where do you find all this stuff? You find everything on the website. Pictures of the new website. Boards and commissions. Ad Hoc By-law Committee, way over there in the right column. No, I can't read that from here either. But that's what it says. That's why I have the big arrow there. And on that page, over on the left-hand side, proposed bylaw updates, which brings this page, which, because it's mine, has a lot of exposition, a lot of text in it, a lot of information describing in more detail everything we've talked about today, I believe. Partway down the page is, in fact, not very far down, this document, which is the 152-page document with everything in it, and more. The introduction, everything that describes our repealed bylaws, and the sections of Mass General Law that the town has adopted at town meeting, they're all documented here.
Does that say Rutland's general bylaws? Is that what that says?
Yes.
Oh, okay.
And just below that is the list of consequential changes, the document you now have. Go a bit further. How you get, not up to date. Every single bylaw that we are proposing is selectable here. You click on the blue part and up comes that document. I know this is out of date because many of these Legal review is now complete. And so what is up on the website today is through legal review and through committee integration. This subject matter expert reviewer, there's a table down below this that lists what all those abbreviations mean. SB is select board, TA is town administrator. They're not difficult to understand, but there they are. Further down still, the thing I wish I could do better. Click this one, you get the current version of the bylaw. Click this one, you get the new version of the bylaw. And alas, I don't know how to have a single link that pulls up both side by side. I'm also, by the way, based on the complexity of the changes we put in, it's not clear to me that trying to compare them side by side is fruitful work for many people, but feel free. You'll get two windows, pull them up side by side, have a blast. Okay. Questions on any of this? Yes, I went on longer than I expected.
So now, okay. I have what is the current bylaws right now. And I'm looking at, it says Chapter 1, Article 1, General Provisions. And it has all this list, but it says General Provisions here, and it only talks about 4 things. How do these changes affect that document right there?
Well, let's go to that document right there. So number 1, I'll just start at the top. We added definitions in the General Provisions Bylaw, Article 1, Section 1. Chapter 1, Article 1. We added definitions that apply to every single bylaw. If it's there, it applies to everything. So that when a term is used, its definition is clear. Anywhere in any bylaw, the meaning of, let's just go pick one. The meaning of the word licensing authority is the same in every single bylaw. That way I don't need to keep defining it in every bylaw. We specifically call out day as a calendar day. There are 7 days in a week. There are seven calendar days in a week. There are bylaws that say that such and such a thing must occur within 5 days. Does that mean 5 days including the weekend or not including the weekend? And so we also, scroll down, created working day as a different. So anywhere in any bylaw that you see working day, we mean any day excluding Saturdays, Sundays, holidays recognized by the town. And if it just says day without an adjective, it's any calendar day.
Okay, so are you saying that right there basically replaces this right here?
Yes, this is our new bylaw.
Okay, I never, okay. Okay.
Since I'm here, I will point out the definition of town official is extremely broad and purposely so. There are people who are employed by the town, the DPW superintendent, clearly an employee of the town. But it includes members of committees who are volunteers, who aren't employed by the town, but because of the way Mass General Law is written, board and committee members are still employees of the town for certain actions and get to act as agents of the town, and that's why we use the term town official.
In some employees are special town employees.
Yes, some board members, some volunteer board members can be made special town employees, which impacts their ability to collect a salary from the town and be a volunteer, et cetera. It's,
Like the 5-member select board right now, because we're under 10,000, are special.
they are
town.
definitionally,
Why isn't, sorry, I'm
Yeah.
asking why that's not put in here, because special town employees are allowed to do things that, when you're going through the ethics training that we all need to go through, it'd be nice to know who, what, where, when, and how are special town employees versus regular town employees. Because truthfully, I know that our select board is now because of the ethics training, but I think we have some others because of some of the potential conflicts.
Cable Advisory Committee were the most recent group to be designated as special town employees. And that was, I'm trying to remember how many years ago that was. It was, I think, before I was on the committee. In fact, I'm sure it was on the committee. So that's several years ago. Nothing has happened since then. And before that, I have no idea who has been designated a special town employee. No idea at all. Finally, the other definition here is committee. You need a word so you don't keep using the same committees, boards, commissions, councils. We just chose committee. So if it's not if it's not the committee, if it's a committee, then it refers to any multi-member body of the town.
That's appointed.
Yes. Any appointed committee member, that's right.
So it wouldn't include the Board of Health, because they're elected.
They are elected, that's correct.
All right, okay.
And that's because us writing bylaws that impact the Board of Health or any elected body is a problematic issue. So says town council. So we go along with that. Another
Okay,
concept.
so let's go to the town clerk is not required, da, da, da. Where in the current bylaws does that come up, or does it not come up in the current?
It absolutely, if it didn't come up in the current one, I wouldn't even mention it. This is not the most recent bylaw. If I go online, let me pull up the most recent bylaw.
Yeah, but
We accepted that
Oh, we did?
bylaw at town meeting.
okay.
We did.
We haven't had a town administrator for all that long in the grand scheme of things.
Come on. Those of you who are amused by how I do or don't do well with using my computer at Conservation Commission are going to be equally amused now. There we go, and then make it a little bigger so we can read it. This is the current bylaw. It's in the section labeled bylaw adoption or amendment, comma, semi-numbering. The town clerk shall hereby be authorized following consultation with the town administrator to assign appropriate numbers to things. We removed the words following consultation with the town administrator.
Mostly because they're very, very, very minor changes that our office is allowed to make anyway. It's mostly just numbering.
Okay,
Okay?
Yeah, okay.
The old section 2 enforcement and penalty. So we used to have section 2, which talked about the ability to fine. And we had a whole bylaw called non-criminal disposition that described a particular approach to enforcement of having penalties assessed without going to court. It's not a it could be viewed as a criminal offense, but it doesn't have to be done in a criminal proceeding through the court. Instead, there is a ticketing procedure. That process is not going away, but the bylaw is. And the important parts of that bylaw dealing with non-criminal disposition have all been brought into the general provisions. That way, we don't have to talk about enforcement through non-criminal disposition in every single bylaw. We also extended enforcement to cover not just bylaws, but also regulations and rules. As it says, if there's a violation that is not, if there is a violation and the fine for the violation is not explicitly defined elsewhere, it is set to $100. We have a schedule of fines, which was the other half of the non-criminal disposition bylaw. That's been pulled out into a whole separate chapter. But if there's nothing in the fine table, but we're allowed to fine for it, the fine is $100. We explicitly allow department heads to delegate enforcement of bylaws and regulations and rules. And we explicitly say police officers are always empowered to enforce every single bylaw, along with regulations and rules, because it's always bylaws, regulations, and rules.
So department heads can delegate. So that means Seth, the fire chief, decides he wants to delegate it to the town administrator, that's acceptable?
The detail in there is that the department head can delegate to someone in the department.
Okay, thank you.
So the police chief can delegate to a police officer, but the police chief is not allowed to authorize a firefighter, excuse me. Questions?
So that means if a police officer sees a problem with a bylaw, any one of them, they can enact and fine based upon that. They do not have to wait for, in the past, we've had like the building inspector is the regulating authority. If a police officer sees it, they can enact it. They don't have to wait.
They can enforce a general bylaw. Zoning's a whole different beast. You mentioned the building inspector, so we need to be, because the building inspector has authority over enforcing zoning bylaw. The general bylaws cannot confer that enforcement of zoning to anyone else. That has to be a zoning bylaw.
Okay, so we have a sign bylaw, does that mean
Yes.
cops can?
Yes, a police officer absolutely can enforce the sign bylaw.
Of course, some people believe that the sign bylaw is better in the zoning bylaw than the general, but that's a whole nother.
Yeah, that's a whole nother discussion for someone else.
For another
since we decided
committee.
not to do that. Now, there are,
That was just an example I could
Yes.
think of
No, no.
off the top of my head, that's all.
so, I mean, equally, we talked about animal control. The animal control officer is the primary enforcement authority, if you will, for animal control bylaw, but any police officer is always enforced to enforce a bylaw. The old, in general provisions, there has, since the last adoption, been a section that talks about the Board of Selectmen being called the Select Board. That's been there for a while. The last time this went through legal review, though, the last time as in, no, never mind. After that adoption, when it went through legal review, as we were trying to push them through that last time, council made changes, and the wording of that changes tells me that that the context as passed today is only with respect to the bylaws themselves. But we still had a body called the Board of Selectmen. The changes that have been proposed by town council, we believe, say the Board of Selectmen doesn't exist. The Select Board exists and has all the powers and duties of a Board of Selectmen as required by Mass General Law. It's a very small wording change, but I believe that's the power of that. And the next section with treasurer collector is exactly the same. Our treasurer collector position was created by a special act in, I don't remember, a long time ago. So in Mass General Law, there is a tax collector and there's a treasurer, and they are two separate offices that would normally be given to two different people. But this town, whatever that long time ago was, combined them through a special act into a single office called the treasurer collector, as opposed to what the special act calls it, which is treasurer / tax - collector. There's a weirdo phrase, or reminding me tax collector / treasurer. I don't remember. I'd have to go dig it back up again in the special act. We now officially have an office, or will. No, today we do have the office called treasurer collector. It's just that the office itself is now called, will, assuming this passes, be named treasurer collector and not whatever that name was in the special act. Severability clause. When you read bylaws, or read any laws, you see it a lot. If any portion, paragraph, subparagraph, or clause of this bylaw is ruled ineffective by a court of competent jurisdiction, then the effectiveness of the rest of the law are not effective. Somebody takes us to court for the signed bylaw about the way it's being enforced. If the court says this section 4A 7BI, whatever, says that section isn't valid, the rest of the bylaw is still valid. That's what severability means, that you can sever out a small piece. Rather than have severability in every single bylaw, we have a single severability clause in general provisions that says that any general bylaw, rule, or regulation is severable. So for those that haven't had it, it will be covered. Anything that didn't have it in the past, it is possible that a court ruling could invalidate an entire bylaw as opposed to just a clause. Those are the consequential changes to the general provisions article. That's another word. I use the word article instead of bylaw a lot. And most of our language of the bylaws has been changed to use the word article rather than bylaw. Why? Well, first of all, nobody knows how to spell bylaw. Is it by space law, by dash law, bylaw without anything else? Get rid of it. It's just called an article. But article and bylaw mean the same thing to us. Okay. No questions. Moving on to non-criminal disposition. We are proposing that bylaw be repealed. And as it says here, the important text elements are moved into the general provisions. I've already briefly mentioned that. And the fine table is moved to its own chapter called the Schedule of Fines. And if you print out all 150 pages, you'll see it towards the end.
I guess that's my question is, where are those things.
Those fines?
I'm complicating the process here and asking too many questions.
Nope, please.
Um,
I'm looking for the question, we're looking to make sure people understand what they're going to be voting on. Because the worst thing in the world is to either say, I don't understand, but I'm just gonna vote for it, that's bad. And saying, I don't understand, so I'm not gonna vote for it is equally bad. I understand and I'm not gonna vote for it, what a great position. I mean, fundamentally, I believe. So the fine table, just a minute, let me pull up the right thing, that's
So
up.
the entire section on non-criminal disposition is being repealed?
Yes.
That's going away?
That's correct.
Okay, so, all right, then, okay.
So all that important text in non-criminal disposition, the things that talk about how the law works, that's now put into that previous bylaw, the general provisions. It's there now. So we're not losing the ability, we're just moving where we define it. Nope.
Come on, there you go. This whole enforcement penalty thing, this long set of text replaces non-criminal disposition and actually properly states a few things that are not clearly stated in law in today's bylaw.
So are you moving it or are
Yes,
you
we're moving
repealing
it. We are moving the text into a new place, into a bylaw that already exists and repealing the thing that specifically calls it out.
Okay.
I find a play on words right there. Table, fine, a fine table, or table of fines.
We
Is it a-
cheated. It's now a schedule of fines.
It's a fine table.
It's a fine table, isn't it?
Yeah, exactly.
Fine is an adjective instead of.
Exactly.
We spent a lot of time on words like that.
Yeah, right, you can too.
I will say,
Norm's the guru.
we have some very serious word nerds on the Ad Hoc By-law Committee, and Anita's exactly right. We spend a lot of time thinking about, is this word better than that word? Somebody comes and says, hey, try this one. Oh, yeah, that's a good idea.
Exactly.
And then we get to strip out all these other words. We spent a bunch of time stripping out words that didn't have value to the bylaw. And then we spent time putting some words back in because they turned out to be important for clarification.
right.
But there's a whole, you can imagine spending 2 hours every Tuesday afternoon.
I've done that a lot, and yeah, I could relate to what you're saying.
So, no, the bylaw text is not identical to what was in the old non-criminal disposition. But we have it, we are not losing the ability to enforce in that way. We'll talk about the actual, we'll actually should go briefly through the fine table at the very end of this. It's it looks very different, but it's all been reviewed by the right people. I just want to make sure Barb doesn't have any more questions, because if somebody's confused, let's try and straighten that out. Turning the page, okay. The bylaw that is today called membership requirement is being renamed appointed committees. Membership requirement was simply, if you're on a committee in town, a board, a committee, whatever, you have to be a voter, a registered voter in the town. That's been on the books for 10 years-ish. But we expanded this bylaw to state a lot of the things that apply to all of the appointed committees that we have.
How are they appointed? Who appoints them? They're always staggered terms. They are, the number of members is always going to be a bylaw-specific thing. But they're always going to be appointed to staggered terms, virtually always going to be appointed to staggered terms. These were things that were repeated in every bylaw for every multi-member body. FinCom, CIPC, Bylaw Committee, AgCom, they all said this, had almost the same words. Today, if we find that someone is not performing duties correctly on a committee, or has acted illegally and been convicted of a crime, the town does not have the ability to remove that person from the committee. We've added a process for that. How does it work? Read the bylaw, there's a hearing, there are ways to go through it. There's a process that the body that appoints a committee is the body that can remove a member from the committee. And the process is laid out in the law.
Convicted, right, of a crime?
The reasoning that the person is removed is left to the appointing authority. I happen to think that I happen to believe that if you are merely accused of a crime, that is insufficient as long as you are adequately doing the duties of the committee. But, if there is, for example, substantial evidence of bribery, that the person is not properly fulfilling the duties of the committee, the duties of the office, that person may need to be removed in advance of conviction. And it's not just criminal. Philosophically, there has to be cause, and the cause has to be before having the hearing, the person has to be notified of the reason he or she is being removed. It's not just we're gonna remove you, it's removing you because you blah, or have been accused of blah, or there is substantial evidence that blah, whatever.
Okay, now you talked about registered voters in the town on committees, is that changing?
No, that's still there.
Okay, all right, good.
So what you just said, has that already been approved by the AG's department? No, okay.
Okay.
But it has made it through legal review, so that gives us confidence.
Cause I mean, I could foresee somebody just going out and getting an attorney immediately.
Yeah.
Once they've been put on notice.
I would expect that, frankly.
Absolutely, yeah.
And there's provision in the removal proceeding to be represented by counsel rather than yourself at whatever hearing there is. And the person gets to decide whether it's a public hearing or an executive session.
But it all falls upon the appointing authority to determine what they consider substantial, what they consider whatever,
Cause,
so.
whatever is
It all
cause.
depends upon who's the appointing authority.
That's
And
true.
the appointing authorities change on a pretty regular basis.
Yes, they do.
Now, would that have to be unanimous within that, authority, within that committee?
Honestly, I don't remember. Removal. By majority vote of the appointing authority.
Just the majority, it doesn't have to be unanimous.
Doesn't have to be even a supermajority.
Right. I would think if it's going that extreme, it would have to be, within,
I would expect
pretty much
quite a bit,
unanimous,
that's right.
really.
That is what I believe is most likely to happen.
That's
If-
the
if-
intent.
If the person isn't that clearly and obviously problematic for the committee, why is it coming up? And I mean, to put it into an extreme case, the appointing authority, well, actually for member removal, for finance committee, it's actually the select board plus the town moderator, which makes a body of 6 people, which can reach a tie. And if it's a tie vote, then the person is not removed, because the motion will be to remove.
Sure.
But if it's not that much, if it's a tie vote, then it's not that clear cut a case. And maybe it should not have been brought in the first place. Other questions? Moving on. Oh, that's wrong. Crap. I haven't updated this since legal review. No, we did not rename annual town meeting the spring town meeting as
Oh,
much as
thank
I wanted to,
God.
and we didn't.
That's
That
good.
would,
It still says it in your proposed on the website too, by the way.
When did it say?
Just now, the spring annual town meeting.
Ah, okay, so we still use the term, but we also still refer to it as the town's annual meeting, so. That's, we changed it the way that council said to, so.
so what is it gonna be? What's it gonna be known as? The annual town meeting?
By the bylaw that's on the website, it's the spring annual town meeting.
Oh, there we go, spring annual, even better.
You don't have a fall annual town meeting.
That's just
No,
what
that's in
I-
C.
Hold on,
Where it
it's-
says the
it's
fall
coming down.
special town meeting.
No, you-
Regular fall, we believe,
Oh, you're gonna have two,
But
huh?
annual means once a year.
because
Used to be.
hold on, let's be careful. Every town must have an annual town meeting before June 30th. Must. And in fact, I believe it must be February through. I thought there was,
Yeah, I think.
it's something like that.
yeah,
That
it doesn't
Mass
start in
General law says you need an
January,
annual town
Right
meeting.
through June 30th.
And then you can have as many specials as you like. Because how long have we had November town meetings?
How long?
How many years in a row have we had November town meetings?
Yeah, okay,
It's regularly.
all right.
One of the benefits of defining things in the town meeting bylaw is so that everyone knows what to expect a long time in advance. So if we say, when we say the date of the annual town meeting is basically fixed to a calendar event, that we're suggesting very strongly that there should also be one scheduled in the fall, because there's always one in the fall. Even this year when we didn't have money measures to do, there was still the fall town, the November town meeting. And the town can still have as many specials as they like. I'm just saying that if we tell people in advance that we know, that everyone will know when it's going to be. For those who come to town meetings regularly, it's good to know when the town meetings are going to be. For those who don't come, it doesn't matter, but.
Yeah, Peter, can I say, our discussion on the committee started because, for years it was, anything substantial should only be done at the May annual town meeting because people don't know when the fall meeting's gonna be, so they can't plan. And we started talking about, because a lot of towns do it, that they have that set date in the fall, so it opens it up to being a meeting that people can count on at a certain time, and then easier to offer, substantive bylaw changes.
So is the fall town meeting then gonna be the second Sunday after the first full moon kind of thing? I mean,
The third Thursday of November or on
Is what-
any such date as
Or- yeah,
scheduled by the select board.
Yeah,
Because it also depends upon when we get free cash
Right,
qualified.
that's
So
why
if
we
there, if
couldn't
there's
set
any
it.
money, I mean, it's like, so yeah, we're telling you it's gonna be then, but flip a coin, cause it kinda depends. Now thankfully, we've got the right people now
We'll probably
to get stuff squared away, but now you can put this on your calendar, but write it in pencil.
Exactly. We wished it was
Yep.
set, but it's more of a suggestion.
So you're moving the town meeting
Yep.
to be
The Saturday
After
following the election, yes.
election. So that is that's a change
Yep,
from
right there,
how we
second bullet
currently
item.
do business.
Yep. And it
Can
is
you
the
ex-
way that we used to do business.
Exactly, but then it was amended on the floor
Mm-hmm.
and enacted by the town meeting on
Like 2014 or 15.
2014 or 15, yep, whichever one it was. So why are we going back?
Exactly, that's my question.
Okay, it's a good question. On balance, and I remember, this is a balancing act among competing interests. The amount of work required to do town meeting and an election that close together has become well nigh impossible. Well, very, very, very difficult, and increasingly so over time, for the town clerk's office. And so what happens if we don't get the work done in time for, if we aren't ready for elections because the town meeting took such and such a time? What happens if the other way around? What if we don't get the town meeting work done because it had to be suspended for the election to get that done in time?
But the election and the annual meeting are so close together either way.
That week made a big difference to our office, and part of it is now we use like the check-ins with the poll pads and then the clickers at town meeting. So we have a town meeting on a Saturday night, can last till 10 p.m. further. For years, we heard complaints from people in attendance that the next day was Mother's Day. So the idea was try to get it away from Mother's Day, but mostly, like right now, our office, I mean, we've done it for almost 10 years now, so we manage, but we have to set up for an election on Friday night, then we have, and we just don't show up at 6 o'clock for the town meeting. It's all day preparing for the town meeting. Sunday, we're back in the office reprogramming the poll pads so that the election can open on Monday. It's not ideal. And I think part of when our town voted in like 2014, I think was the end of the year, to change it, we did not have a town administrator in place. And I think that's why the people that were proposing it felt at the time that, that would they wanted the select board, they didn't want somebody that was out of, or brand new elected arguing. But right now, it's the TA that handles the arguments and the discussions at town meeting most of the time.
But some of the changes that are coming up are going to affect some of the way the business is done if the town administrator does not, and then you could have, as we had this past year, 3 members of the select board change, and then they all go, I wasn't part of it, which is why Mr. Bracebridge brought it up.
Right, it was
For
Eddie,
that
yeah.
purpose. And yes, we have a town administrator, but there has been several years where that hasn't gone the way we've hoped it would go.
The other thing is that the select board members that are outgoing, maybe they can argue it on the floor, but they're not gonna be the ones in the office for when all of whatever gets voted is implemented. It's going to be the new select board members, so.
Yeah, but when questions come up
Right, so
about,
on the floor.
I mean, when questions come up on the floor, if the selectmen, the changes that are coming up, which we will see shortly, the selectmen will be providing the budget if the town administrator does not do it.
Right.
Would be that there's a potential that 3 people who made those decisions could in all theory not be at the meeting.
Right, and the only other, And like I said, I get why it was
Foundation
changed and
events.
proposed, but the other reason is that we don't go back and just separate it and push the town meeting date out is because all 5 towns in the Wachusett School District have their town meeting on the same day, and that allows the schools are closed, so that we can use the schools, because all the town clerks in the region use the schools. So that's why we didn't,
I think you said meeting and I think you meant elections.
move the election out, yeah.
That is
And,
part of the meeting, but.
Yes, so, but,
But the other thing would be is like last year, the importance of getting the word out. We did informational sessions for the 2.5 override, but it was also important on the night of the town meeting to get the word out so people would vote for or against the town ballot initiative that now might not happen as well as if you put stuff in front of people's faces. And truthfully, I know you get a lot of FaceTime with people that might not come to an information session like this at a town meeting versus, is there a way we could purchase more poll pads so that you would have the 2 that you need to sign people in for a town meeting?
they're relatively reasonable, but there's a annual maintenance fee of every poll pad, so per poll pad, which is one of the reasons why we haven't, and it's not in the budget to do so, but that's why I've been reluctant to buy more poll pads, and it's mostly the maintenance. I think it's $500 per poll pad, and we already have 4 of them, so. Like I said, I've done it since like 2015, and we manage, and I think in the back of my mind, it's always been something that I didn't want to pass on to another town clerk, but.
Well, the unfortunate part is there's pros and cons on either side. It is good arguments, you could sit here for hours saying why you should or shouldn't, but I think one of the big things that we've already, Finance Committee's talked about also, but I remember way back when the discussion was about changing it, one of the big things, when you have the town meeting on Saturday night, and if you're asking for an override question on Monday morning, you can at least, as you just said, it's laid out, the budget's laid out, here's the problems, the reason that the town is asking for X amount more money or for debt exclusion or whatever is because of this, and the people that are at the town meeting are certainly gonna be the people that are gonna go to the polls for sure, and they would have the information, and that was one big reason, so. But, I mean, we could, like I just said, we could sit here and come up with lists on both sides that are
This is why I said,
very important.
on balance, it is the committee's opinion that this is a better choice. As I've said it before, I'll say it again. Floor amendments are possible.
But now, if it does, just to clarify this, to make sure I understand, if somebody does want to amend this, that means it all just, like you said before, no picking pieces.
Well, we're not suggesting that we're hoping someone would not say, let's not change town meeting because of all the other changes in it. But a floor amendment could be to change the word following in the appropriate section to the word before. That's an amendment that could be proposed on the floor.
Yeah.
You can propose anything you want on the
Yep,
floor.
any change you want.
You're a taxpayer, you're a voter, you can do whatever you want on the floor. It may not get voted through, but you can propose whatever you want.
Other questions about date or positioning, calendar positioning of town meeting? Fourth bullet item. You might remember a couple years ago that we moved town meeting to Wachusett Regional High School. We could only do that because of COVID. Without a bylaw, the
town meeting must be within the geographic limits of the town. One of our proposed amendments is an ability to move it to an adjacent town. So if we decide we need to move it to Wachusett, that we have the ability to do that, or to Quabbin, or,
TCU Center.
that's not adjacent, I'm afraid to say.
Too expensive.
So what situations did you anticipate that would require that?
Well, we know how big, we know how large the space is for Glenwood. We know how large the space is for Naquag. If we have a reasonable suspicion that this year's town budget is going to be so controversial, I'm just picking on Wachusett, you know that. I don't, but if we think there will be a sufficiently high turnout that we can't meet the communications requirements of town meeting, and law states those. So, for example, first thing to do, we know we have the big gymnasium, fully opened up, bleachers out, the whole thing, and that holds a certain number of people. Well, if we have too many people, there's a way to get to the cafeteria downstairs, assuming that we can get audio and video bidirectionally there, so that they can be active members. The part about town meeting is anyone who's present must be able to speak and be heard. And so there are audiovisual requirements to make that happen, technological requirements, if you will. But we know how big the cafeteria is, and it's not really big. So if there was a reasonable belief that we can't fit the people in Glenwood, what do? We at least have hey, we could go outdoors again, outside of Glenwood, which was a fascinating experience.
We're lucky it worked.
We're lucky, we're all very happy it worked as well as it did with all of its issues that it did have. But no, I don't know anybody who wants to hold a February meeting outdoors that's gonna be and again, this is all hypothesis on things that can happen.
That was it's quite broad though. It's quite broad in scope as far as.
And that's one of the reasons we limit it to an adjacent town, because, again, if you wanna think about disasters, Glenwood catches fire 2 nights before, or 2 months before town meeting, we've gotta have it somewhere else,
Or it's just booked.
potentially.
We have issues getting space at the
For
schools.
specials, that's absolutely true.
So it could be booked.
It doesn't, if the Wachusett High School auditorium is full, doesn't the overflow go into the cafeteria? And they set things up in there
For the Holden Town meeting.
for the Holden Town?
Holden Town
Exactly.
meeting does that. We Rutland have not ever had to do that happily, and I don't know how we would do that, because we had enough problems with the sound system at Wachusett that last time that we did it.
So it wouldn't be possible, if you were anticipating an overflow, to have the meeting at Glenwood and then overflow at Naquag?
Well,
Yeah, go
I
ahead.
did investigate this a few years back, and we looked at the cafeteria downstairs in Glenwood, okay? And it's serviceable. In other words, yeah, we could reach there, and there's a PA system within the building that we could patch into, and so on and so forth. These things were not tried out, but they were investigated and found to exist. Okay, so there is that possibility if we have to.
And actually, the problem with remote locations, the biggest problem, in my opinion, with remote locations is not the technological piece of it. It's not how does someone speak. How does someone notify the town moderator that he or she wishes to speak? How do we do that? I don't know what the answer to that is. We haven't looked at it. Having it in a single space simplifies the problems, reduces the number of problems we're going to have. So having the ability to move it to a different location, I would think, out of town would be a benefit, having the option.
The better idea.
Yeah. Again, I believe it even says, the bylaw says that will normally be held within the limits of the town, but under certain extraordinary circumstances, it can be moved by vote of the select board.
That is a good point to put in there.
That's in the bylaw itself.
All right, okay,
It's not here in this
Yeah.
text, but it's in the bylaw.
okay, yeah, thank you.
In fact, we had proposed that it was a discussion amongst the select board and the moderator, since at the end of the day, it's the moderator's town meeting. But council said, no. Until town meeting begins, it's the select board's authority to place, to set the date, time, location, and contents of the town meeting. The current bylaws definition of notice of town meeting is location, posting in 5 public locations in town, I believe. So, if we put on the website, that's now 1. In addition, we clarified what has to be in the notice, which is really mostly defined by law and by Mass General Law anyway, but town meeting, the website is a valid place to post town meeting warrant, is what that's all about.
And that's one of the sites, or that covers all 5?
No, that is one site.
We still post now, though, in
Oh, no, I know, but
5
you're not
spots in
changing them, that's the state law, isn't it?
Yes.
The 5
5
sites? Yeah.
public places. But we've also, the select board also accepted the website as an official pub.
That's-
Right.
Yeah, that makes
So
sense.
it could be, I mean, we could reduce it to 4 buildings instead of 5 because one of the publications is the website. I'm not saying we should, I'm not saying we would. I'm just saying that the website has become a public posting location.
If you didn't post a warrant in 5 places, you wouldn't have 5 gatherings talking about the warrant around town. You gotta have
Right.
something to talk about.
I think we were coming from that we wanted it on the website
Right.
too.
Right,
Yeah,
You know,
yeah,
that
that
it
makes
should be
sense. Yeah.
there, but
I've already mentioned this once, quorum has been changed from 10 to 30 voters. We also specify, we do not run town meeting by Robert's Rules of Order, we run it by town meeting time. That has actually come up at town meeting several ago, and figure explicitly stating it makes a lot of sense, so everybody will know. Even though it's virtually impossible to find a new copy of town meeting time, and they're in fact overdue for the next edition.
Now, why, just curious, why did the town never go with Robert's Rules of Orders?
for as long as I know, the moderator has used town meeting times and over the course of different moderators, so. And I don't know if it was ever specifically, it was never in bylaw.
I don't believe it ever was in bylaw. I
It's not
believe.
in the bylaw.
No.
Neither
No,
one of them.
but I
No.
believe that it's chosen, town meeting time was chosen because that's the
Moderators.
preference of the Mass Moderators Association. to
Oh,
which our
okay, all right,
moderator
okay,
belongs.
all right,
So
all right,
it's,
that makes
we're not
sense.
the only town that uses town meeting time
Okay,
by
got
a
it.
long stretch. And by the way, it is, for a nerd like me, town meeting time is fascinating because that book talks not only about what the rules are, but where the rules came from and how court cases have changed them over time, which is why they're overdue for a new edition, because it hasn't been done in a long time, well over 10 years now. Yep, go ahead.
So that's specified in the bylaw now, so that's gonna change the town meeting, the town's town meeting bylaw will no longer be in existence, it's gonna be that.
No, the town meeting bylaw, this is part of the town meeting bylaw will to say that we run town meeting, the rules of procedure are defined by town meeting time. So we're specifying that as the
Okay.
source of the rules of
So I'm
procedure.
assuming then what you're saying is town council is, because our town bylaws have very specific provisions for some of the procedures that take place, so those now are in sync with town meeting time or vice versa?
They're either in sync, or if they are not in sync, the bylaw, the way it's written is that the town meeting bylaw takes precedence. if
Precedent
there's-
over that?
Over town meeting time,
Okay,
yes.
okay, all right.
The next bullet item, no action on capital articles unless CIPC has considered the article. That actually came out of the old CIPC bylaw, but it didn't make sense to have something that defines town meeting action in the CIPC bylaw. Let's put all the town meeting stuff together in the town meeting bylaw.
But if a citizen's petition comes up, that doesn't have to go through CIPC.
That is true, yes. Citizen petitions are exempt from that particular. And even then, if CIPC has been given time and has not considered, now, considered means discussed and made a decision on. If enough time has passed, then it's also not it's also bypassed, that the town is allowed to take action.
Is that new?
No, it's in the CIPC bylaw today. We have as a town,
Harry
Been
stands up,
doing it?
yeah, Harry stands up every single time it hasn't gone through CIPC and says, hello, this hasn't been, you, come on.
oh yeah,
He stands up at every single one if it hasn't gone through.
and every time that happens, has been a violation of our current bylaws.
Well,
It's another thing where we went with where we had to answer the question, what should the town do? And the town should have CIPC consider it. But again, we believe that by putting it in the town meeting bylaw, it becomes more obvious to people.
The ultimate authority is the voters that are sitting there at the annual town meeting.
Yes.
Those are the people that run the town, and they vote. So now the townspeople can't make a decision, because it has to go to a board of 3 or 4 people to say yes or no, we don't wanna do this. So,
To determine what, well, let's.
I understand, I understand what you're saying. I
CIPC,
understand that some things have not gone before them, but the ultimate decision is the voters of the town when they're sitting in that meeting.
right,
So they should have the authority to do what they wanna do, period.
It was the will of the town when the CIPC bylaw
You're
was
right,
passed,
absolutely.
that the town should not take action on those articles if CIPC is not considered. And we changed that by saying there's an amount of time. If we'll give them time to do work, but if they don't, again, CIPC doesn't tell the town what to do. CIPC makes a recommendation on particular capital projects. And
so if the CIPC says no to something, just like the finance committee frequently says, no, we recommend against this article. If the CIPC says no, the town meeting could still go ahead and say yes or no or not.
Yes, it's just that
The
they make,
article has been placed.
right, the article's
But
placed.
that's not what that thing right there is saying. It's saying no action on capital articles. Oh, never mind, I take that
Yep.
back. Never mind, I take that back.
If they say no, all it means is that CIPC doesn't look favorably on it and
Okay.
believes the town should not vote favorably for
The
it.
CIPC has considered it and the
Yes.
town is saying, we don't care, we're gonna vote for it anyway.
As long
Correct.
as the article's been placed.
Okay. Gotcha. Momentary confusion.
When someone makes a motion, let's talk about a motion to amend. At the upcoming town meeting, somebody wants to change the town meeting date back to before election, fine. All motions are supposed to have been in writing, and the current bylaw does not say when that writing has to be given to the town clerk, because the town clerk has to document and include as part of the package to the AG's office every amendment. It's already supposed to be in writing. What we said, what we changed, is that motions must be in writing, even the town clerk, before voting on the motion. Makes it very clear. Sometimes that will cause a stall in town meeting. Randy will vamp. Hopefully, people who are planning to amend bylaws in February will
have them all written so that they can, but again,
Doesn't
it's,
make a difference yet. We
well,
can still wait.
it does, only if the moderator allows that. At the last couple of town meetings, he's taken this model where you have to give it in writing before, because that's a rule of town meeting.
I don't think he's asked for it before we
Oh, yeah.
vote. I thought it was before the end of the meeting.
No, before you, it used to be before the end of the meeting. The last couple of meetings, it's been before the vote. And note, this is also on a,
Making up rules as he goes along?
He can do whatever he
he can,
wants. He's
that's
the
right, town
moderator.
meeting is his. He gets to set.
Oh,
can do
okay,
whatever
so
he
the
wants.
answer is yes, okay.
Yeah, he can do whatever he wants. I mean, subject to town meeting time, but town meeting time is not, does not say anything about motions.
I actually have
Oh,
some
right.
carbon paper, and I have brought carbon paper and a pad to a town meeting in case somebody wants to write up a motion, and then they have a copy to read and a copy to give to our office, so. Took me a while to find that carbon paper.
Yes, ma'am.
Can I just get some clarity on
Sure.
that part that says motions must be in writing? So at the town meeting on February 15th, if there's something in the bylaws that we don't like or we wanna change, before we come to the meeting, we need to have that in writing to give to the town.
That is best practice, but if somebody wants to make an amendment on the floor, they can write it out right then and there. That's certainly happened. I've seen it.
So
We all
what
have.
happens when you give that motion in writing to the town clerk?
That's for her records. The town, so at some point, the moderator asks for discussion, debate on something. And somebody gets up and say, Mr. Moderator, I
Wish to amend
move
the
that we,
motion."
that we amend. Back up. Town meeting always, everything, all discussion takes place with respect to a warrant article. And the warrant article is read, and then a motion is made by someone. Now, those motions have already been handed to the town clerk. So somebody making a primary motion won't need to do that. But anyone who wants to have a motion to amend will need to write out that full motion and get it to the town clerk, again, before the vote on the motion.
Because if
What
it
does that sound
passes,
like?
if
What
it
does that
passes.
look like though? So do you just say?
You literally write down what the motion is, Mr. Moderator, or just even without Mr. Moderator, I move the town modify Article, Chapter 2, Article 2, Section 7B to change this word to that word.
And then we have to submit that actual copy, if it passes, if the amendment passes, we have to accept. So I can't just take what somebody says and type it up. It has to be the motion as it was read on the floor and what they hand to us. So that's why we need the motion.
So that's why I say it is best practice. If you know you're going to make a motion to amend, have it ready. Because number one, you can read it, and it's a lot better than winging it in front of the town. And number two, you can hand it in and solve the process problem right away.
But then we're not voting, is the town then voting on whatever motion that?
Whatever
I
that's right.
propose?
Each motion is a separate vote. So the primary motion, I move to adopt chapters 1 and 2, whatever. And then I want to modify chapter 2, whatever, is a separate motion with a separate vote. Separate debate and separate vote.
Okay, so for example, we were just kind of talking about renaming the annual town meeting to spring town meeting. I'm just putting
Sure,
this out there
absolutely.
as just for clarity. If I wanted to say, oh, I don't want it to be called the spring town meeting, let's keep it annual town meeting, I would want to amend
Yes. So
chapter
to do
2,
that,
Article 1.
to do that, this is a little more complicated because it's bylaws and it's all lots of text that people have to read, which means you need to get the formal
Okay.
text of the bylaw. So you know exactly what you're asking to amend.
Okay.
Which I sort of made up off the top of my head
Right.
Chapter 2, Article 2, Section 4B, to remove the word spring in all instances, something like that.
Okay.
And then once it's, if the amended motion passes, then the town meeting goes back and they have to vote on the original motion as amended, and then there's another vote. And sometimes it gets crazy and there's a couple of votes.
It can get crazy.
But if it's not voted on, or if
Then-
it doesn't
then-
pass, that copy is, well, whatever,
We keep it in our files,
and
but
that's sent
Yeah, and it still goes into the
the-
minutes, doesn't
if it
it?
doesn't pass, the Attorney General doesn't
Doesn't know anything about it.
It's only if it passes, and our minutes reflect that it passed.
The minutes reflect all motions, right?
Right.
Right, so no matter, there is a document with every motion that's made. Other questions on this? What did I do? The wrong way. Anyone know how long you're allowed to talk?
10 minutes,
Well, 10 minutes on what?
one subject.
Is a subject a motion, a primary motion, a subsidiary motion?
On the motion.
That is up to the town moderator, is the answer to that question. What does it mean?
No, our town, our
spiel.
bylaw specifies a time and the number of times you can talk.
Yeah, it does.
The current bylaw does.
But it doesn't say what the scope of the talk and the time is. It does not
It
adequately
has to
define.
be related to the motion you've presented.
Right, again, which motion, the primary or the subsidiary?
And when there's
The
another
subsidy-
motion, you can talk 10 minutes in a second.
That's the point, this is the point I'm saying. We're all guessing what the bylaw today means.
No, I'm not guessing, it says
We
it
have,
in there, but then the town
It-
moderator takes care of it.
right, we clarified it, number one. We reduced it to 5 minutes, because 10 minutes is a long time.
Long time.
So we amended it to 5 minutes
I got the old one.
on a motion. We made it explicit that it's a motion. It's not topic, it's not anything. Anything else. You're allowed to talk for 5 minutes on a motion. So that means that if there are 5 amendments pending, plus the primary motion, that's 30 minutes somebody could take of town meeting time. And I know people who would do that.
And who's responsible for keeping time? The moderator?
The
Says right
moderator shall appoint a timekeeper.
You get a little timer.
Yep.
What happens to, what if you're presenting something that's gonna take, like right now, it's taking more than 5 minutes to talk about,
Town meeting can vote to extend the time.
that's in there.
That's in the bylaw.
Okay.
The new one?
Yes, ma'am.
just going back to that debate time. So this is a time that residents can use to talk about the motions that they wish to amend.
Yes.
Okay.
It's the, and actually, to be a little more clear, it's, they can talk for 5 minutes on each motion independently,
But the motion that's on the floor at that moment.
is what they, so, to introduce an amendment, you need to get up and speak, and you'll use part of your 5 minutes from the primary motion to propose an amendment.
So going back to that first example, if I wanted to amend the naming of the town, I can use 5 minutes to talk about that motion and
Yes,
why.
yes. So you would use it to set, you would normally use it. When you speak at town meeting, it's either you're pro the motion, you're against the motion, or you want to change the motion.
Or you have a question.
Question, that's true, that is also very true, thank you, that's a fourth.
Yeah, but a question doesn't count for that.
Yeah, it does.
If
That's
you ask
speaking
a
on debate.
question,
Sure.
Asking a question is speaking on debate. If you are addressed, if the moderator allows you to speak, you are part of the debate, even if the debate is nothing more, even your, that role is nothing more than asking a question. Those are all
So somebody that has several questions probably is not gonna be able to talk to them. Sometimes people have questions.
There can be series of questions, and I would expect that the normal flow is ask a question, get a response. The response time is not part of the questioner's time. And then ask another question,
Then
get
there could
another
be a
answer.
follow-up question
Yep,
to that answer.
yep.
That 5-minute debate time is based on a single warrant.
A single motion on a single warrant article motion.
Right.
Yes.
See, I think there are times when the moderator just allows somebody to keep talking and talking and talking, and they haven't done, and they haven't said, okay, your 10 minutes is up.
Didn't have his timer going.
Didn't have his timer
Yeah,
going.
right.
I don't know,
He liked what the person was
it's too
saying.
short.
Look, there are people who we know are going to need a timer. I'm one of them. Everyone knows I speak at length. And there are people who just get up and ask a question. There's or a series of questions. It doesn't take that long. And in truth, if one person has a question, more people have the same question. So there is always some leeway. But we did want to start capping somebody pontificating. Okay, me. You want to shut me up.
Set the timer.
Your 5 minutes are up, Mr. Crane. Sit down, please. Other questions on that?
Not me.
So we have a mechanism. We explicitly say that non-voters are allowed to speak with permission of the town. Basically, somebody, either the town moderator is allowed to ask for objections, or the town moderator may ask the town's permission, in which case there's a quick vote. And finally, we have a provision for a secret ballot when requested by somebody in the town and voted to go to secret ballot.
So why is that necessary now that we have those little doohickeys?
Because technically, somebody by law is still allowed to request a secret ballot.
I
It
thought
is-
that was the way it is now.
But isn't there still with the little doohickeys, there's still a record of the number associated with the name, so you could go back and know who
The
voted
fast
how.
answer is that we as a town, as our practice, don't store the records. But a practice can change on a whim. To make those stored on a whim, I hate to say it that blithely, but
On a
it's.
vote of the town.
No. The town moderator, the town clerk or assistant town clerk, whoever's running the system, will operate the system. We here today know that we don't keep the votes, but nothing says they can't for some other reason that I cannot predict.
And that doesn't have to go to the town.
No.
The other thing that we've done after the last meeting, because it was slow, we've decided that the only reason we wrote the number down of the clicker was because the clickers are pricey.
Right, you wanna get it back.
But it does slow the check-in process, and Randy's very good at wanting to start on time. And so we're gonna give it a try, and I think that we're not going to write the numbers down this time and just really have enough people there to get the clickers back. But basically now, as soon as the vote's taken, we have no idea who voted or what, or who even has what clicker. And
It would in fact take multiple things. Number one is keeping a record, an individualized clicker-based record of the remote, because that's what comes out of the system. And someone could choose procedurally to keep that, and then also to keep the record of who has what vote, and to tie them together is a manual process. But it's a process, it's feasible.
So then, if someone was to ask for a secret ballot at this point, because there is the potential, everyone has to file out,
Yep.
Yep.
get a piece of paper, rip off yes or no, come in and put it in either spot.
If somebody actually still asked for it.
Yeah, if somebody asked for it, yeah, that's.
But the body has to vote to do it too, so. And the last big debate was when we did the
Limiting the
exactly.
building permits.
And people on both sides voted no to a secret ballot. I still always thought that the
was
outcome could have been different, because it was such a close vote if it had gone to secret, but it would have been time consuming, so. I mean, the clickers work,
They do.
so I don't anticipate people asking, but they have the right to ask for a secret ballot.
Okay, can we go back to the non-voters for a sec?
Sure. Non-voters, a voter of the town, a registered voter of the town is the only person who by right may speak at a town meeting.
Right, and they sit in the main body, and people that are sitting up in, well, at Naquag anyway, it was people sitting up in the bleachers were non-registered voters, okay? And they would say, can this person speak? And they would say yes. Does that get rid of that, can this person speak?
No, it doesn't. In fact, it explicitly allows that person to speak.
Well, they allow that person to speak now.
But today, that's by convention. We're making it law that the town decides from whom to hear.
Oh, okay.
The body that's there.
Yes.
Oh.
The body that's there votes to allow this person or not to allow that person to speak.
That was
So
in our
they're-
bylaw already.
They're not allowing non-voters into the main body of the meeting. But they're sitting off to the side and they can speak if they want to. Okay. Oh, okay.
But even the sitting off to the side in the separate section is a convention of town meeting. They physically can sit wherever they want to sit, really. The moderator stresses at the beginning, if you're not a registered voter, go sit over there. And then sometimes there are multiple
Because a
sections.
non-registered voter could, even if you're doing a count vote, a non-registered voter could still stand up and vote.
Right, and that's why they mentioned, we've always had them
Right.
to the sides, but now with the clickers,
The separation is not as necessary it was in terms of the integrity of the vote.
the only thing that I worry about in our office, make sure, is that technically a couple could come in and each have a clicker, and then for some reason, one of them decides to leave and hand the clicker to a spouse. But that's why we make sure that we have people, sitting outside rather than in the body, in the vestibule, so we get any clickers back if somebody's exiting the building. And hopefully nobody would do that, but you never know.
There. Town meetings.
It's still the purest form of government, and when how your voice counts really counts is in town meeting, but
Ready to move on to our friends, the select board. Yes, we added explicit number of members and their terms. Remember how I said that CIPC had this one thing about town meeting that didn't really belong in the CIPC bylaw? Select board responsibilities were spread throughout the body. We did our best to collect them all into the select board bylaw. So many of those changes are just moved from that other bylaw over here. Many powers may be delegated. Yep, okay, it's just explicit. My problem is I can never find a Mass General Law section that describes delegation of powers. There's a section in the current bylaw about everything that we're going to purchase, we're gonna use the Uniform Procurement Act, chapter 30. That's been moved into the town administrator bylaw, who's the chief procurement officer.
There is a section that says the select board may pass regulations for power boats. And they did, except that that section of Mass General Law was repealed in 1960 along with any regulations promulgated thereunder. We explicitly say they are the CEO, the chief executive of the town. One of the powers of the select board is the ability to give money away. And specifically when the town is sued, that the select board normally has to go before town meeting to allocate the funds to pay off an adverse judgment. Well, that's already in the bylaw. It's today $300. We raised it to $1,000. How can $1,000 payment be enough to pay off a real judgment? And the answer is insurance. It is the opinion of town council and the bylaw committee that $1,000 limit has to do with the insurance and co-pays and premiums and all of that. That's the $1,000 limit. It's not that the judgment can only be $1,000, because $1,000 will not cover a court judgment in the best of times. As the chief executive in the town, it's the select board who are responsible for initiating prosecutions and defenses and implement contracts and dealing with annual report stuff. All of that was in the current legal affairs bylaw. They've just been moved into this bylaw because they're actions and requirements of the select board.
So the town report, committee reports
Yep.
falls under the select board,
Well,
not the town administrator.
the sections dealing with legal affairs are the select board's responsibility to write.
Okay, thank you.
Doesn't say who's responsible for the town report.
Okay.
FinCom had a bylaw, part of the current finance committee bylaw says that the select board shall refer all warrant articles for their consideration. And there's the same kind of thing in CIPC and the same kind of thing in bylaws for bylaw committee. Each of those was sucked into this bylaw because they're all responsibilities of the select board. As voted by the town meeting in 1974 and supported by S 2371, the select board acts as the Board of Public Works. It is a fascinating distinction, though, that they are two bodies. Board of Public Works is legally a separate body from the select board. And the actions, you have to be in a meeting of the Board of Public Works to take Board of Public Works action. You have to be in a meeting of the Select Board to take Select Board action, which is why many meetings, this Monday, tomorrow's meeting, is posted as both, because they are also doing abatement requests, which is a Board of Public Works responsibility. They are two bodies composed of the exact same people. But the law defines two separate bodies, and so they have to act as two separate bodies. We went through a lot of appointments. Who appoints what? Does the does a town administrator appoint? Does the select board appoint? Many appointment powers have been moved into the TA, because in practice, that's what's happened for the past several years. But there are some that by law must be done by the select board. I believe police chief is one that the select board by law is the appointing authority. which is different from the fire chief that doesn't say it must be done by the Board of Selectmen. So anywhere where MGL says appointed by the Board of Selectmen, our bylaw says the Select Board shall appoint. Remember way up earlier, I talked about removal powers. There are removal powers to remove the TA. There had better be. It is a power of the Select Board to speak at appointed committee meetings where they are the appointing authority. You just wrote it down. And the town administrator, being effectively, yes, reports to the Select Board, but in terms of function, is a partner to the Select Board. The town administrator is given voice as a full, non-voting participant in Select Board meetings, open session and executive session. Questions on any of that?
So where in the current bylaws is all that?
Most of that isn't in the current bylaw, that's why it's new.
So
These
these
are all
are new.
virtually added, yep. Yeah. Added. Explicitly state means we added. State means we added. Those are virtually all additions.
So we don't see what your wording is.
It's in the new bylaw proposed, which is online.
And if you look at the old selectmen bylaw, it basically says nothing.
Well, yeah,
Yeah, that's.
so word for word online, it says sentence by sentence. It's
Well-
not just a bullet, it's the full, complete sentence.
Yes, complete sentences there describing each of these powers.
That's what it says online.
Okay,
It's multiple pages.
okay.
This is,
Yeah.
this is a 152 page document.
That's why we didn't print them.
But, I'm sorry?
That's why we didn't print them, because of the 152 pages.
No, I guess it's just that, like I said before, I have to have a computer over here to look at what the old one is and a computer over here to look at what the new stuff is. And I just don't think people are gonna do that.
Well, if you're in, for those who are interested in doing a line-by-line analysis, you're right, that's the only way to do it. That's one of the reasons we wrote this, so that people can understand what the changes are, what the consequential changes are, without having to read each of these in context, or in turn.
And I would've brought my iPad, all that, yeah.
I've been working on this for a couple of weeks.
Okay. All right, that answers my question, thank
Okay.
you.
Brand new town administrator bylaw.
This is
Oh, we-
brand new, there's
Yes.
nothing in here
Correct.
to compare it with,
I
okay.
had one.
This stands alone by itself.
And we took way too long to have one.
Yeah, well, it was, and this is another one that took a long time to write because we looked at several towns' TA bylaws and we tried to pick what we thought were the best parts of each and put them together. And then it went through review and got changed some more. But fundamentally, the town administrator is the chief administrative officer of the town and responsible to the select board for everything that he does is responsible to the select board. Acts as the chief human resources officer. He has very broad appointment and removal powers. Chief financial officer, chief procurement officer, chief information officer, responsible for the administration of grants, And the main point of contact for media, state and federal governments. I mean, that's a very fast whip through 4 pages of bylaw, maybe?
I think it's about that.
And the town has absolutely nothing now.
No.
Correct.
No, the only thing that we currently have that mentions the town administrator is that it's the last section of our select board one, and that just gave them the ability to hire a town administrator, and that's the only mention in any of our existing bylaws of a town administrator.
So he doesn't even have a job description?
He has
Well,
a
no,
job
no, that's
description, but not a
different
bylaw.
than a bylaw, but he does have a job description.
One thing to say about broad appointment powers. I'm gonna pull in 3 things I've already talked about. The select board by Mass General Law has a number of positions that they themselves must appoint. But powers can be delegated. And therefore, most of the appointing will in fact be done by the town administrator in practice. Department heads, all the employees, except employees of elected officials, which is a whole another separate thing. But that's not very many, and soon one fewer. Moving on, the Board of Public Works. There is a section in the current Board of Public Works bylaw that lists every town property that they're responsible for, which is woefully inadequate. Doesn't talk about the schools, or at least not all of them. So instead, we made it more general. It's the town administrator is responsible for the care and upkeep of all the town property and all the buildings. Town buildings. This next bullet item is out of Mass General Law, which is, and in fact, Mass General Law says more than this, but the Board of Public Works has the power of road commissioners, water commissioners, and sewer commissioners. We have not had those positions since 1974, when the town created the Board of Public Works. But all of those powers are conveyed directly into the Board of Public Works, so they still have that responsibility. We have some words in there about town dumps, where it used to say it's the operation, but now we talk about capped versus uncapped, because if it's a capped, there's no operation, and so responsibility and authority goes to the Board of Health. That whole stormwater thing, which is gonna be a lot bigger in May than it is today, but the Board of Public Works, the stormwater system is a public work. That's my baseline statement. Therefore, the Board of Public Works has authority over it. The current stormwater bylaw conveys a ton of authority to the select board, which is an error. We are fixing that to be Board of Public Works. But we have an explicit statement about it in the Board of Public Works bylaw. We tell them they have to appoint a superintendent, although you don't have to call him superintendent. Our current appointee is a director, as was our previous. Doesn't matter what they call it. Someone needs to have the authority of the superintendent of public works by Mass General Law. And finally, because other bylaws need it, the Board of Public Works appoints a tree warden. There. That's our foundation. A lot of things build up on duties. Questions on anything we've covered so far? Moving on to chapter 3, financial affairs. There is currently an accounting and collecting bylaw. We have split that into treasurer collector to talk about the duties of the office and accountant to talk about the duties of that office. They are separate offices with separate duties. So we split the work between them appropriately. There's a couple of sections that are actually in common between them, but in the treasurer collector, most of the changes are structural only. They are not consequential. But we added a few more duties for the job description based on the request from the treasurer collector. There were other duties mentioned to other town officers and select board. They were all pulled out and put into the right place. And the accountant bylaw is effectively the same as what it is in the duties of the town accountant are now in that bylaw and pulled out of the treasurer collector one. Moving on to the finance committee. All the stuff about membership that we covered elsewhere and the appointed committees bylaw, that's all pulled out of here. The town moderator always appoints under all conditions, where that's not always true in the current bylaw. But if for some reason the town moderator is not available and they need to fill a vacancy, the finance committee can itself fill a vacancy in the same way that they can today in the bylaw. All appointments, no matter how they're done, are ratified by the select board. And we clarified the ratification process. We didn't leave it open-ended. We send a date, well, not a date, but we limited how long they have to ratify. And if they don't ratify, it's ratified, if they don't take any action. The appointment term no longer begins right after town meeting. The appointment term now begins the 1st of July and goes to the following June 30th. The FinCom's budgetary role, operating budget, is primarily advisory.
Changed to advisory. Peter, you know, for the last 3 years, it's been a lot more than advisory.
I know that the FinCom for a long time has acted in a much broader capacity than advisory. I recognize that.
So now that we're advisory, why is it that we can only sit on one committee? I understand when we were more involved.
Yep.
But now that we're stepping away and the selectmen take all of the responsibility if the town administrator doesn't do his job, then why do we have to be impartial anymore? It should be no different than sitting on multiple things for CIPC or sitting on multiple things for Conservation Committee or whatever.
The fast answer is, the question that tries to answer is how should the town behave? And as I said, that's not how we've worked with the bylaw changes. That it turns out to be a very interesting question, Karen, and I am not saying it's not, it's a very good question for somebody to answer, but this bylaw committee are not the right people to answer that question. Because the same question that you're asking is being applied differently to CIPC. And how should both be applied? They should be applied equally, whatever that is. But we don't have
the expertise to define that well enough in bylaw, in our opinion. There is certainly a lot of discussion that will go on about that in the future. No doubt about it.
And where does it currently state, in which bylaw does it state that if and when the town administrator does not complete a balanced budget, it is the selectman's duties?
It's Mass General Law. It's not in our bylaws.
Okay. It's Mass General Law.
Yeah, that the select board ultimately is, as the executive, is responsible to ensure that all executive functions are performed. Whether they do it through a town administrator or themselves or through some other department, that's their responsibility. And if they shirk that, well, if they shirk their responsibility, there won't be a budget at all, and there's a whole nother problem, but the problems grow, no doubt about that. The direct implication you can draw, though, is that very early in the TA bylaw, it says that the TA is responsible to the select board for all functions. So it doesn't say the select board has to do it, but it does say anything in this list, select board's ultimately responsible for.
But then it does go on in the finance committee bylaw to state that we're advisory only. Nowhere in
I don't
the,
think it says only anywhere. So should,
will advise the town administrator in refining and revising the
Yes.
proposed operating budget.
Yep.
When the town administrator doesn't do it, it doesn't say that we can then do the same with the select board.
you're right, it doesn't say that. And it also doesn't say that the select board can't delegate those, the budgeting responsibilities to the finance committee. Because at nowhere does it say the finance committee shall not. And delegation confers the authority to act. I do not dispute that there is still lots more work to do in financial management, in bylaw and in practice.
Well, considering, I would just like everyone who might be listening later on to pay attention to the board, to the finance committee's meetings that have gone on for the last 3 years and how much effort the finance committee did regarding the budget without direction from either the select board or the town administrator.
That is, this town owes the finance committee a huge debt in the responsibility that FinCom has taken on. Anything else on FinCom? CIPC, there's a lot done, I've already talked about a bit about the town meeting bylaw, things moved out of CIPC into town meeting. Anything that belonged in the bylaw was moved out of CIPC. It's also, there's a very important change of word that for the CIPC does not generate the capital budget they create a plan. And at the end of the day, as the town administrator, as part of his chief financial officer roles, is responsible for the operating budget and the capital budget. Capital requests flow through the town administrator because that's the new process.
So they go to the town administrator before the CIPC?
Yes.
Okay.
And my best recollection is that that was at the request of a CIPC member. But I could be wrong, because this is my memory, and don't ever trust my memory.
That's fine.
We talked about that next bullet enough. Extraordinary circumstances, which is what allows the Capital Improvement Committee, CIPC, to consider a capital expense. In the current bylaw, it must be a unanimous vote of CIPC to grant that a condition is extraordinary to the circumstances. That's been changed to 2/3. Again, again, per my recollection, at the request of CIPC. As in so many other places, remove the membership, sections covered other places. And finally, CIPC does not prepare warrant articles, so I don't know why, and CIPC doesn't know why that's even in the current bylaw.
I have a question on membership.
Yes,
The committee shall be composed of 5 members who are not employed by the town.
yes.
So the chair of the CIPC currently is employed by the town because he is a selectman.
He does not receive regular salary from the town. He receives a stipend periodically. Therefore, he's not an employee of the town.
I thought
Or,
under
no, excuse
general-
me, I said that wrong.
I was
He
gonna
is
say-
not therefore employed by the town.
Okay,
He is an employee anyway, that's why we removed all the
Yep.
employee wording.
that's what I wanted to make sure of.
But in the very first article, you said that a town official is an employee of the town.
But this doesn't say you can't be a town
No,
official.
no, I'm not
No, no.
questioning what I'm just saying, the definition you just said that you can't, if you're an employee or you're associated, then, but the first definition then would conflict with what you just said.
No, because the words are very different. One includes employee in the definition of town official. But CIPC does not say anything about an employee, said is not employed by. And to be employed by legally mean to draw a
Town
redemptive.
official and you're employed,
But we're not saying town official.
and you even said, even if you're voluntarily employed, you don't get any compensation, so, well, I'm just saying,
That's still
I'm
not,
surprised town council, said that was okay, cause that's a conflict.
that's because they're not. Somebody who's a volunteer is not employed by the town.
Correct.
It is a weird condition of law that someone is not employed by the town and yet is an employee. That's mass general law.
No, I understand what you're saying, I knew that.
Anything else on CIPC? I mention revolving funds only because that's where it's going in the book. We aren't changing it. It was amended in May 6, 2023. We're not doing anything with it. Moving on to legal affairs. So the current legal affairs bylaw is really based on how the town is supposed to deal with legal matters like suits, defense or prosecuting, whatever. But those have all been moved out, usually to the select board. And what we did instead is we said, here are the duties of town council. This is what we expect that office to do for us.
some of the important things. If you read it in depth, they're going to act on our behalf to review things, to go to court or go to the legislature on the town's behalf, under the direction of the Select Board of Town Administrator. This was some element, there's actually some controversy within town about this, but we're stating in law, in bylaw, that to get to town council, you go through the Select Board of the Town Administrator.
Regardless of who's paying for it?
Yes. Unless there's a law somewhere else that says you're allowed to talk to, and there are a couple of those. We have had committees go directly to town council and incur costs that they did not have a budget to manage, to pay for it. That has happened even recently. And that's really why that's there. And likewise, employing special counsel, anybody other than town council, you need permission before you contact special counsel, even if the special counsel is not getting paid for the work.
So wouldn't the town council say, somebody calls them up and says they want something, wouldn't they say,
I'm sorry, I can't talk to you, go through your town
do
administrator.
we have, yeah.
They've already punched the clock, they're starting to charge.
Yeah, when they pick up the phone, they're charging for a quarter hour, period.
Right.
When they read an email, they're charging.
I mean, I've always been under the impression that it's the Board of Selectmen that communicates with town council, that people come to them and say, hey, can we talk to town? I guess I didn't realize that people were just calling up town council and asking.
Well, different boards have reasons to reach out to town council and pay for them from their own funds and have that in their funds. So that's not an issue versus, as long as they can pay the bill, it shouldn't be an issue.
Oh, okay, I just
Yeah, 'cause there's-
always thought everything got channeled through the select board and as far as town.
It's always supposed to be.
It's
yes.
supposed to have been done that way, but it hasn't, yes.
But this is just an aside note. Many, many years ago, there were people or committees that would call town council, ask a question that had already been answered by town council to the selectmen, or from some other circumstance. If they had asked the selectmen first, they would have had the answer without having to pay again.
Right.
So that's why way back when, that was, you gotta go through them, because that's where the budget is, and that's, you know.
Right.
Some people in the lower part of the pot of the whole scene don't know everything that's going on at the top of the pod.
Absolutely. What we're doing is we're changing it from policy to law.
Right.
To do that.
I don't disagree with it, but okay.
Do you have a 5 or 10 minute break planned or anything?
Well, we've got about 20 minutes left, maybe less. So if you want a break, I'll break.
No,
You okay?
not for 20
I
minutes.
should have asked that like a half hour ago. That would have been
We
good.
get 20
You may
minutes
wanna
left.
include
When our other
that.
guest, whose name I do not know, left, would have been a
you think
good
the
hint
town
that we should have taken a break.
They want to include it in future,
Absolutely. Thank you.
We've been having this much fun so fast?
Okay.
Oh, Jesus, it is.
Licenses and permits of delinquent taxpayers. The bylaw fundamentally says if you owe taxes, the town can either refuse to issue a permit or can revoke your permit. That's what it says.
Right now?
There's more in it. Yes, that's what it says right now. And we're not changing the intent. There are lots of wording changes and structural changes, but they don't change the meaning of the bylaw. Okay. I'm only gonna go through these next two and then we're gonna stop. I know everybody's happy. There's a current bylaw called public drinking that talks about what happens if you have an open container in public without a couple of exemptions. By request of the police chief, that has been expanded to include marijuana. This, you might remember from very early, is one of the ones we don't have feedback yet from town council. Fundamentally, all we tried to do was to make the conditions for products containing THC roughly, effectively the same as what they are for alcohol. I am concerned that town council didn't say, yay! Instead, they have more comments to make, so we'll see what changes, but that's substantially or consequentially all that changed in that bylaw. Yes.
There's some problems I'm seeing with this bylaw as of right now. It says consumption or possessing an open container is not allowed within an area of a public way, in any public building, on any public property. Every Friday night in the summer, we got a lot of open containers. I'm just saying.
Yeah.
I am
Fourth of
not
July.
saying that this needs necessarily to be strictly enforced. I think even public drinking is not strictly enforced.
They issue a permit for that, don't they?
Doesn't
They
make
issue a
it.
permit for that.
No, but it
That-
says you can't. You can sell it, the permit's to sell, not to allow public drinking.
Well, actually,
you
it
should-
depends on how the license is written. Cause the licenses up at Memorial Field tend to include consumption on site, which makes it legal to drink there on a duly licensed activity.
But not walk across the street to Dunkin' Donuts.
Correct.
It doesn't say anything about the town common.
Town common is a public space and therefore it is subject to this.
I remember when the town first passed one of the original ones, and I don't even know if I was in the town clerk's office, but I remember Kenny Viner saying at town meeting, okay, if I'm on my riding lawnmower and I go over onto the other side of the sidewalk and the strip and I have a beer, am I in trouble? But that's my little ode to Kenny.
God bless you, Ken.
Yeah, really.
He was very thoughtful.
Makes sense.
He was.
One of the other reasons that we made this change, today, there is no licensing for public consumption of marijuana, but I can see Massachusetts going that way, that they'll allow it, but will require, So if they're doing it on the roadway, that's always gonna be illegal, just like drinking on the public roadway is always illegal. Smoking marijuana may not always be illegal on public property if it's licensed appropriately by the select board. This opens that option should it ever become possible. Now, I'm not gonna discuss what I think is a good idea or a bad idea, I'm just saying this is where we were thinking.
What's the money on Friday night?
Moving on to unregistered motor vehicles.
booth.
I'm thinking I'm gonna pay to have the police go out and start handing out tickets
some
on
rounds.
Friday nights. There goes the budget deficit, paid for. I'm sorry, you're on public way, $100.
There's a current bylaw that says you may not have more than 2 unregistered motor vehicles or parts thereof, disassembled, whatever, in the open on your property. If you have more than 2, you're in violation, blah, 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 motor vehicle licenses, yeah. And farm vehicles are also exempt. We're not changing any of that. This is structural. Any questions on anything so far? We're through chapter 4. There are 8 chapters, means we're halfway through, right?
I think it's a good time, you got a good idea to have a break right now, so.
I think we're gonna break for the week. I will plan better for
Yeah, yeah.
halfway through.
So now if somebody comes next week, they come in on chapter 4.
Yep. Oh, actually, we'll start chapter 5 next time.
Or
We're done with
whatever.
4. Yes.
Okay,
Sounds good.
I'll bring my iPad.
And I won't give the presentation next time because you all seen it. Thank you all very, very much for attending. I like the back and forth
Thank you.
we had today.
Thank you.
I'm
Thank you.
a huge proponent of debate. People know that, and it doesn't matter whether or not I agree or disagree with the debate, with the content of the debate. It is the debate itself that has value. So, Norm, I think it's time for a motion.
Exactly.
Motion to adjourn.
Don't wanna think about that one?
That was quick.
Roll call, Turca.
Aye.
Anderson. Carlson.
Aye.
Crane, aye. We are adjourned at
3:40.
It is.
3:40.